Welcome to Public Forum, a community outreach program produced by North Idaho College located on Lake Coeur d'Alene. Featuring guests from around the globe addressing a wide variety of subjects, Public Forum serves to educate and enlighten. Please join host and moderator, political scientist Tony Stewart, in welcoming today's guest.
Welcome to the 9th program in a 10-week series titled Americans' 225-Year Search for Personal Freedoms. It's been such a special privilege for us to bring you this series, and we will conclude it next week. On today's program, we'd like to discuss Brown versus the Board of Education, which took place and was decided in 1954. And we're going back in history with our Chautauqua format and welcoming to our program the two attorneys or lead attorneys that addressed that case in 1954, although it had been before the court in 1953, and there was a follow-up in 1955. First of all, I welcome to the program John W. Davis, who lived from 1873 until 1955. He was known as an American jurist, served in the United States House of Representatives from the state of West Virginia, was U.S. Solicitor General of the United States from 1913 to 18, was U.S. Ambassador to Great Britain from 1918 to 21, and was the Democratic candidate for president in 1924. He argued for school segregation, representing the state of South Carolina. Mr. Davis, welcome to the program.
Thank you, Tony. It's a pleasure to be here.
And I'm so pleased to welcome to the program Thurgood Marshall, who lived from 1908 until 1993. He, too, was an American jurist. He was the first in his 1933 graduating class at Harvard Law School. He was the chief legal counsel to the NAACP and represented the NAACP before the court in the famous Brown case, as Mr. Davis represented the state of South Carolina. Mr. Thurgood Marshall won 29 of 32 cases before the United States Supreme Court. He was Solicitor General of the United States, and he was the first black person appointed to the United States Supreme Court, where he served from 1967 until 1991. Mr. Marshall, welcome to the program.
Thank you very much.
And as always, I'm so pleased to have regular panelist Janelle Burke, who will commence the questioning of these two attorneys as they represented their different parties before the court in Brown versus Board of Education.
To begin my questioning, I want to point out that Mr. Davis, you are considerably older in time than Mr. Marshall. You are about 25 years older, maybe a little bit older than that, than Mr. Marshall. But what I would like to ask you to do is set the factual background for Brown versus Board of Education. Can you tell us what the facts were in that case?
Well, basically, Janelle, there was a situation where the actual case argued before the Supreme Court of Brown versus Board of Education is a set of consolidated cases that were before the court, and I was actually not involved directly in the Brown versus Board of Education side of the case. I was involved in a case called Briggs versus Elliott, having to do with the segregation of schools in South Carolina. But I think it is fair to say that in all cases, Brown, Briggs, and the others, that primarily the plaintiffs, appellants at the Supreme Court level, felt that they were wrongfully being denied equal access to schools by mandatory segregation statutes, which were in effect in each of the responding states. So, in those general terms, that's the background.
And how many states, do you know roughly how many states had such segregation laws or practiced segregation at that time?
Well, at the time of the argument, the number was 21 states had segregated schools, and 4 other states, I believe it was Wyoming and Kansas and New Mexico and Arizona, had segregation that was permissible on a local school board by school board basis. And then the 21 states had mandatory segregation.
Now, Mr. Marshall, would you want to characterize the facts in a slightly different way? As we often know, attorneys look at facts depending upon their situation somewhat differently. Do you have facts that you would like to add to that?
Well, the fact of the matter is that we were talking about equality and under the 14th Amendment. And access to education was far from equal in the state of South Carolina. Black children were going to substandard schools. They were walking to substandard schools. They lived in some substandard housing. It was separate, but not equal opportunities to education. And that's not only true with the state of South Carolina, as we know. It was also true in many other states. The other fact of the matter is that Plessy versus Ferguson in 1896 set a precedent whereby states that were not segregating education, opportunities to education prior, were so compelled during the Plessy era to segregate schools. And so the fact of the matter is, in the side that we, the NAACP, took in this case, was that it was not equal, but it was separate. And there's no such thing as separate equality.
I have studied this case for a number of years, being a political scientist, but I've learned more in preparation for this symposium and for you to be on this program than all of those previous years. And so I was really fascinated with the idea of the different approach that you, Mr. Marshall, used and the one that Mr. Davis used. And the area that I want to focus on is the 14th Amendment's Equal Protection Clause. And maybe I will start with you, Mr. Marshall. From my research, I think you had over 80 great experts that met with you in Chicago, and you're to be commended with the brilliance of how you put all this together and the advice you got. But it's my understanding that the great challenge that, one of them at least, that you faced before the U.S. Supreme Court was that Mr. Davis would have some documentation trying to prove that when the 14th Amendment was adopted, along the whole series, the 13th, 14th, 15th Amendment, particularly the 14th, that it was addressing the issue of slavery or the aftermath of it and did not address public schools. In fact, in the 1800s, states were not involved in public schools the same as they would be in 1954. How did you prepare and how did you convince the court that the 14th Amendment had a broader umbrella and would in the future not only have this particular breakthrough for you, but would be in other cases like women's issues in the 1970s? How did you prepare that argument? You knew that you faced this challenge from Mr. Davis about what was the purpose of the 14th Amendment.
Yes, which is why I prepared for, in anticipation of that question, spent a lot of time putting that together. The one thing that you mentioned there that is so accurate is that we decided to take the position of social scientists. We used a lot of historians, used the work of historians, used the work of psychologists, in part because we knew that Mr. Davis, who had long been before the U.S. Supreme Court, would use a legal argument. So for the first time, we used a social scientist approach to the issue of segregation and the harm that it was having on Negro children psychologically. We looked at the slaughterhouse cases in particular, 1873 and 1880. And in those cases, what we determined was that the U.S. Supreme Court had taken consistently the side that equal protection under the 14th Amendment, when trampled on by the states, was unconstitutional. So we used the slaughterhouse cases. We also used the Sweat versus Painter cases and McLaren case as precedent for how this court had repeatedly sided with those who took the position that their individual rights were being denied under the Constitution, under the 14th Amendment. And so we used history, we used the social scientist approach, and then we used previous cases that were brought before the court. In the case of selection of juries, in the cases of occupation, where the court said that yes, in fact, the judicial branch was ruled over state rights.
So both in the McLaurin case and the Sweat case were good examples in addressing higher education.
Exactly.
There were actually another case, there was three, one from Missouri, one from Oklahoma, one from Texas, in which they chose to use the 14th Amendment to deal with the issue of integration of those schools. So that had set a precedent.
Exactly.
And so by using the sociological and psychological data, did that give the court a better opportunity to expand the 14th Amendment to the public schools?
That was our bet. Our bet was
And you
that.
won that bet.
And we won that bet. We also wanted to make sure that the court understood that as long as there was segregation of schools, as long as that stood, it was a way of planting that badge of inferiority on Negro people, and that was harmful.
Mr. Davis, we're interviewing after the case has been decided, so it's not in suspense, and it's our understanding after some years passed and even after your death that the court was divided 6-3 with 3 Southern justices on your side, and then Chief Justice Warren, with his great persuasive powers, got them to vote 9-0. We've learned that later. You probably never knew that in your life, and at least you got some votes on the court originally. How would you talk about your strategy? I know that you weren't very interested in using the minutes and the discussions and debates in Congress when the 14th Amendment was applied. What did you try to convince the court to do that they would not do in relation to the 14th Amendment?
Well, I think realistically, one way you have to look at it is, excuse me, whether or not you look at this case as being a case regarding human rights, or whether you look at this case as being regarding constitutional separation of powers between the federal government and state governments.
So your great argument was that it was a states' rights issue?
We saw it very much as a 10th Amendment issue, and that is that, as my distinguished colleague has mentioned, Brown versus Board of Education was not the first case that the U.S. Supreme Court had dealt with the issue of the interpretation of the 14th Amendment as it related to the ability of state governments to make decisions that pertain to what we consider to be primarily local issues. And but over a number of years, there's been some small erosion of states' rights in that context. And I know that South Carolina, my client, felt very strongly that any attempt to use racial issues to expand the federal definition of what was equal protection over what the people, elected representatives and people of South Carolina thought was inappropriate. And that, of course, was probably our great mistake in defending the case, was ignoring to some extent their psychological data and concentrating.
You kind of called it fluff or something.
Fluff.
You didn't really try to address it, did you? Well, you did address it some with the research of Dr. Clark, was it?
In general, in terms of our preparation, we felt it necessary to call a couple experts, and we felt it actually had a little more basis for rendering opinions than the experts called by the NAACP. But obviously, the issue of the actual effect that the experts felt that racial segregation had upon the children and minority families was compelling to the court. And perhaps we were not able to project our 10th Amendment argument as strongly as we would have required.
While you were arguing the 10th Amendment, your honored opponent was arguing under the 14th Amendment that no person shall deny equal protection of the laws. And the argument that was that if you use law to separate, that you affect the key words, Mr. Marshall, you get the credit for this, and it's right in the heart of the decision, that you affect the hearts and minds of the minority children in a way unlikely to ever be done in this lifetime. And you kind of ignored that, didn't you?
Well, it's, like I say, we didn't see the case as being a race case to maybe the same degree as the plaintiffs did. And in my career, I argued against a grandfather clause that kept persons, black heritage from being able to vote. And certainly I didn't view the case as being a racial case at all, but much rather maybe going back to some of the pre-Civil War divides. And that is that, how do you interpret the words equal protection? In Plessy versus Ferguson, the United States Supreme Court came and told us that equal protection was consistent with equal facilities. And separate but equal.
In 1896.
1896.
But now you're in 1954.
Well, the 14th Amendment was, of course, predated Plessy versus Ferguson by 30 years, ratified, 24, 22 years before Plessy versus Ferguson came out. And my client, South Carolina, and the other states involved adopted their laws based upon what they thought Congress was attempting to do with the 14th Amendment. And if you had asked the United States Congress in 1866 if it intended to have mixed schools, it had said no, because the same year that Congress enacted the 14th Amendment, it set apart segregating schools in Washington, D.C., that very same Congress. And so if you look at it from that historical context, it's pretty easy to see that the intention of the writers of the thing, the 14th Amendment, did not consider that to affect the state's ability to regulate schools within the boundaries of their own control.
Okay. Thank you. Janelle Burke.
As both of you are aware, precedent plays a great role in the development of law. Mr. Davis, do you see this particular opinion as being a major shift in the direction of the law?
I think that prior to the decision issued in 1954 argument of Brown versus Board of Education, there had been some erosion of states' rights towards a more federal reading of the 14th Amendment and a broadening of equal protection. And to the extent that this is a direct repudiation of the separate but equal document announced in Plessy and reaffirmed many times since, I think that, certainly another advocate in my position, appearing before this court again, is not going to be able to argue that separate but equal is okay. That argument seems to be history.
Now, Mr. Marshall, what about you? Do you see that as a major shift? Did you see it as a continuation of what had already begun?
My approach to it and my colleagues was that there had already been a crack in the armor, so to speak, and with history, and that now we are in 1954, in 1952, 1955, the conditions were now right.
The timing was right.
The timing, the social, cultural conditions were right for such a statement to be made by the U.S. Supreme Court. Now, during the 1860 period, of course, we're talking about just shortly after the Civil War. North and South were divided on many issues. So that time was definitely right for Plessy, for the Plessy Court. But now in the 1950s, we're a much more sophisticated nation. We are a much more educated nation. And so the conditions were right. And so with that little crack made in history, we decided to push for a little wider opening.
And you were able to find the facts to support your case.
Yes, in those previous cases, as I mentioned, and also with the states that ratified the 14th Amendment, and those who only after the Plessy Court decided to segregate. If it were not for Plessy, we would not probably be here today, because those states would have chose to leave their schools integrated. They did not forbade integration.
I do not want to take away from the power of the arguments and the incredible preparation that went into the case, but sometimes does fate intervene? While you were in this 2 to 3 year process, the Chief Justice of the U.S. Supreme Court died.
Yeah.
When President Eisenhower appointed Governor Earl Warren of California to the court changed for the next many years under the Warren Court.
Yes.
And also another member of the court who died very shortly after this decision was very ill, and Mr. Warren got him there to hear the argument. In your preparation and consideration, Mr. Marshall, of course, here's the new Chief Justice. You're not sure where he's coming from.
Yes.
although he had a progressive record in California. Did you use that in any way in preparation, or how would you respond to the fact that fate could have intervened? Would you, if that first vote was 6-3 under the Warren Court, and if the Chief Justice had continued to live, could you maybe have lost 5-4?
We, after the first session, to be honest with you, we felt that we were lost. We had lost. We were prepared to accept defeat. The court was split. The death, the premature death of Vinson, we felt both good news and was both good news and bad news in a sense, in that at least we knew Vinson, Chief Justice Vinson. Well, at least we knew his record, so he was familiar to us. When he passed, we had no idea who was going to come next, what their record might be, and when it was announced that it was Earl Warren, my colleagues and I were concerned because we also knew that Earl Warren played a part in the internment of Japanese Americans during World War II. And so some of us gathered to try to think of how that might play out in a case involving Negroes when it played out to the detriment of Asian Americans, Japanese Americans. So we were concerned, to say the least. It was both good news and bad news, in the sense we were not sure who we were going to face next. But once Earl Warren came onto the court, we realized soon after that we had an advocate. And although I'd like to think that I argued a strong case, I truly believe that it was Earl Warren's court, his leadership, that really brought this to our favor.
I want to give you more credit. And I brought the question about fate, but even though he certainly became not only ally of yours in this case, his whole record down the road became one of a liberal justice, and,
yes.
and you had Douglas and Black and others that worked with him on. There's never been a court that's active as the Warren Court, dealing with all kinds of issues, reapportionment, Miranda rights, interracial marriage, getting rid of anti-miscegenation laws. But, Mr. Marshall, you gave the Chief Justice data that he used. Many people may not know, it's a very brief decision, like 2 pages. But as I said earlier on the show, your sociological and psychological argument was exactly anytime you look at that case today and you pull out the most significant paragraph, it's a sociological paragraph.
Yes. Yes.
Mr. Davis, how did your colleagues and you prepare after the death of Chief Justice Vinson? Did you have some kind of the same question marks about how Earl Warren would be?
We were very concerned about the sociological data, and the feeling that at some point in time this case has become more of a case about racial privilege or racial rights than we originally viewed it as. And we, of course, after the 1952 arguments, felt that we had won the case. Matter of fact, we didn't think it should be close because of our interpretation of how the court would view the right of a state to enact legislation having to do with something so fundamental as the education of children at a local level. When Chief Justice Warren took the bench, there was a concern when the 5 questions that the court propounded to both sides in terms of the re-argument. I would say that we may have underestimated Chief Justice Warren's ability to put together a unanimous court. But I know that after speaking with my colleagues, we are, if the case was going to be decided on racial grounds, we're glad it was a 9-0 as opposed to a 6-3 decision, just for the health of the nation. But we think they should have paid more attention to states' issues.
In dealing with the final decision, if you go back in history, Mr. Marshall, and I know that on the court for years that you were there, that you looked at a lot of these cases, we had that awful case, the Dred Scott case, in which the court recognized human beings as property. Then you had Plessy versus Ferguson that's separated by in-facilities. I want to get your reaction to the fact that how the McLaurin case and the Sweat case and those that were, I look at it this way, it took Plessy versus Ferguson, it started chipping at it, and
Yes.
just gradually, and then overturned it in 1954. In your later years, and after being on the court, and you were on the court while Earl Warren was still there, you got there before he left. As you look back on near the end of your time on the court, you must have remarkable feelings about what this case and in decisions that you had on the court, that you got an opportunity in life to change history along with others.
Yes, I felt very, that at the time of the Brown versus Board of Education decision, that I felt very proud to have played a part in that case. I felt very proud of the NAACP. I felt very proud as a Negro, as an American. Once on the court, it was a lifelong dream to someday serve on the U.S. Supreme Court, something I had thought about for
And to be the first person of your race.
Well, I didn't anticipate that exactly, but I'm glad that it happened that way. But as I look back on it from where I sit now in later years, those were glory years.
I have to interrupt. The clock always wins. I'm so sorry. I do want, before we go off the air, let them know who you really are. I want our audience to know that Bob Bartlett has been Thurgood Marshall. He's a sociologist and teaches at Gonzaga University, a fine institution, and a wonderful man. And thank you for doing this. It's been so great. And also Rich Cook, who's an attorney in the state of Idaho. And he said to me, it's very hard to play a role you don't believe in, but Rich, you were very effective in doing that, and he's a former student at North Idaho College and now is a very successful lawyer in our community. You both have been wonderful today, and the audience enjoyed you very much, and you've proven how many hours you put in. And Bob, you really have convinced people you're an attorney that you aren't. You're not that effective. You just did a marvelous job.
Thank you.
And we thank both of you for being with us. I know Janelle joins me in that deep appreciation. Ladies and gentlemen, it's such a pleasure to bring you this special series titled America's 225-Year Journey in Search of Personal Freedoms. We have one more program. This is running throughout much of the summer, and we shall bring that program to you next week. And it's a group of guests dealing with women's issues, and I'm sure you will enjoy it. Until then, please have a good week. I am Tony Stewart.
Recorded on the campus of North Idaho College, Public Forum is the longest-running entirely college-produced program on PBS. Each episode is pre-recorded live and is an educational outreach from North Idaho College. Please join us again at this same time next week for another edition of Public Forum on this public television station.